Live and recording.
Thank you, Sharon. Good morning, everyone, and welcome to the joint meeting of the Board of Trustees and the Committee of Bar Examiners of the State Bar of California. Today is Friday, March 13th, and as a reminder, this meeting is being recorded. The Board and the Committee of Bar Examiners met jointly in January as part of our continuing discussions on options for the bar exam that California should administer beginning in 2028. Today's meeting is the next step in that discussion and will focus on the draft risk-benefit analysis. The board and the CBE will be providing direction on this draft so that staff can finalize it for discussion and action at the committee's April and the board's May meetings. Can I request a roll call of the Board of Trustees?
Barahona, not present. Buenaventura, not present. Cisneros,
Here.
Good.
Here.
Gore,
Here.
Grande,
Here.
Harrison,
Here.
Huser,
Here.
Giorgiello, not present. Sowell, not present. Stevens,
Present.
thank you. Tony,
Present.
thank you. Chair, you have a quorum.
Thank you very much. Alan?
Thank you. Thank you, Chair. Thank you, Chair. Devin, can you call the roll for the committee?
Bolton,
Here.
Burns, not present. Cow,
Here.
Bingora,
Present.
Kaplan,
Here.
Kramer,
Here.
Lawrence,
Here.
Fee,
Here.
Macy-Walla,
Here.
Montgomery, not present. Reed,
Here.
Reyes,
Here.
Reyna,
Here.
Silva Guzman,
Here.
Smith, here. Yokelson,
Here.
we have a quorum.
Thank you. Jose, back to you.
Thank you. Next on the agenda is the call for public comment. Before we begin public comment, I would like to remind everyone that under the Bagley-Keene Open Meeting Act, public comments must pertain to items that are on the agenda or be related to matters that are within the jurisdiction of this agency. Specifically, the board is the state bar's governing body and is responsible for exercising oversight of the state bar. The Committee of Bar Examiners exercises oversight on admissions matters, including the California Bar Exam, the first-year law students exam, moral character applications, and law school regulation. State Bar staff will attempt to call members of the public in the order that they appear in the attendee pool. For those who are participating by Zoom video, you should have a function for virtually raising your hand. It is a hand icon and should appear at the bottom center of your screen. If you wish to address the board, please click on the hand icon now and State Bar staff will call on you in order that the hands are being raised. For those who are participating by phone, you may virtually raise your hand by pressing *9. That is the star key, then the number 9. Again, doing so will alert staff that you would like to make a comment, and State Bar staff will call on you and open your microphone so that you can address the meeting. For those who are participating from a noticed location, please alert the State Bar staff member present in the room that you would like to make a comment. Please note that staff will have on-screen countdown timer visible to all attendees during the duration of your public comment. The timer's two-minute countdown will begin as you start your comment. The on-screen timer will flash throughout the final 10 seconds. Before we open public comment, I'd like to keep public comment to 20 minutes, so we'll see how we go with the number of people that are here. Why don't we begin public comment?
Certainly. Chair, before we start, there was a person who was slated to give public comment before the Committee of Bar Examiners meeting at 9 a.m. this morning when that public comment period opened. I think the confusion about the two meeting agendas, they thought that the meeting started at 9, and so we would like to accommodate them. We had the chair had approved them having 5 minutes for their presentation, and so it's not, though it's not related to the item on the joint agenda, it is related to an item on the Committee of Bar Examiners agenda, and so we were hoping you would indulge that request.
And I do see that advanced sign-up name in our attendee pool. So Jessica Jacobs-Ditch, your mic has been enabled.
Thank you.
Please go ahead.
I'm currently completing my final session of law office study, repeating the third of 3 previous sessions that were rejected without due process. While I should have been able to sit for the bar last July, I'm without question eligible to sit for this July. Admission staff may not agree with that, but their determination is based on a procedural deadline and internal calculations that are not supported by Rule 4.29 or the Business and Professions Code. Their calculation says I'll be short 2 weeks of study by their unpublished July 14th eligibility deadline. However, there are 3 paths, all aligned with the rules, that show I will complete the required study in time to sit for this exam administration. Avenue 1. As of today, I've completed 177.5 weeks of the required 192, if my completed and certified weeks are all counted, not including rejected sessions. There are 5 surplus weeks from 2020 and 2021 that staff is not counting. The mandatory session cover sheet has an error stating that 24 to 26 weeks counts as 6 months, when in fact it is just 24 weeks that constitutes a half year of credit. There's nothing in the code or the rules that prevents these weeks from being accurately counted. I did not forfeit surplus weeks just because they were recorded on a form labeled as a 6-month session. In Duskin versus State Board of Dry Cleaners and subsequent cases, courts have held that regulations that attempt to enlarge the terms of the enabling statute are invalid, and that is what has occurred here. Rule 4.29 is silent on any 26-week maximum or session boundaries, and as such, my eligibility is being hindered by administrative norms rather than any lack of education or statutory compliance, and so I ask the committee to allow staff to count my certified weeks from 2020 and 2021. Avenue 2. Last year, the Supreme Court remanded my case to this committee to evaluate previously rejected study sessions for substance. While the contents of sessions 4 and 6 were contested by State Bar staff, session 5 contained 0 substantive deficiencies, yet was also not credited. As such, the Supreme Court's mandate remains unfulfilled. The court's denial of my subsequent petition did not settle this issue. It only refused to compel the CBE to accept the sessions, but it didn't reject them or strip the CBE of its power to review them. The CBE is not overreaching its authority by reviewing session 5. It's merely completing the task originally assigned by the court. And I urge the committee to consider also the due process implications of rejecting my study sessions without a hearing. I was denied both a moral character and a Chapter 6 hearing on serious allegations, and this is inconsistent with the very laws I am studying. I request that session 5 be appropriately credited. Avenue 3. The published dates and deadlines for the bar exam state just the exam date, the date the application's open, the timely filing deadline, and the final filing deadline. None of these mention a July 14th eligibility deadline. The July 14th final eligibility deadline is unpublished, not in the Business and Professions Code, not in the rules, not on the State Bar website. And under Rule 4.28, time limits are considered norms for processing and not jurisdictional, and they can be extended by this committee for good cause. I will submit my final study packet minus the final signatures in time for review and send the signature page on July 28th, the end of the 24 weeks, the first day of the bar exam. I'm not seeking extension of the statutory filing deadline, only of an unpublished processing norm, and it is most certainly for good cause. The unfulfilled Supreme Court mandate on Session 5, the lack of public notice for the July 14th date, and my completion of much more than the required 192 weeks of study together constitute good cause. I ask that you extend the July 14th deadline by 2 weeks so that I can sit for this bar administration. And to conclude, I have presented this committee with 3 clear, lawful, and fair paths to deem me eligible for the July 2026 bar. I have met and in fact exceeded the law office study program requirements, and I respectfully ask that the committee to exercise its discretion and allow me to take the next step to serving the people of California as an attorney. Quite simply, I completed the work. This is a non-statutory processing issue involving a 2-week window in which I hope to be preparing for the bar. And one last thing, I ask that my eligibility be evaluated strictly under the governing rules and on the merits of my completed study without being influenced by prior staff disagreements or personality issues. The way the law office study program is being run, or has been in the past, is vague and confusing and contradictory to its own internal rules. And I ask that this committee please recognize that I have exceeded the requirements to sit for the bar, and there are 3 very clear paths within the rules to allow me to be eligible. And if you do make that decision, or if you did this morning, and I hope you did, please have State Bar staff notify me today. Thank you so much, and I really hope that this program improves because it's a great program for the for opportunity for people to get involved in this profession without having to spend the money on law school. And I am totally willing to do whatever I can to help the committee and the staff to make this program accessible. Thank you so much.
Thank you for your public comment. Before we move on to the trustees' remote locations, I do want to state for the record there are no members of the public in the San Francisco and Los Angeles State Bar offices. I do see a raised hand from Trustee Harrison.
Yes, I have Mr. Kai on here with me to give public comment.
Good morning, all trustee. My name is Kai On. On October 23rd, 1999 morning, I was searching for my missing father. I drove my car to a scene and a female local law enforcement officer showed me my father's wallet. She told me my father's body was removed from the scene and she made up a story that it was a hit and run. It was just 2 hours from my father was killed. 26 years ago, only political power or a high rank of government official could control Sacramento law enforcement to make up a fake story of hit and run and fake defendant Mr. Jung So Fong killed my father Woon Kong On. Right now, political power once again stopped Sacramento DA Mr. Tien Ho and Attorney General Robert Bonner to investigate DA case number 99F08735 and fake police report from Sacramento Police Department. Political power even prevent Chief Justice, Judicial Council, State Bar of California, and UC Davis Law School to look into the case. California is lawless. How we can say California is a democratic state? All justice system and law enforcement system in California could not protect the California citizen from social inequality. It destroyed the reputation of California, and California government lost the trust of California citizens. All trustees, please work with other legal professions to uphold justice and stop political power to control justice system and law school. Thank you so much all for your time.
Thank you for your public comment. I will ask if there are any members of the public at Board of Trustee members or Committee of Bar Examiners remote locations. I do not see any raised hands, so I'll move on to the advanced signups in our attendee pool. First, we have Nadine Mazard. Your mic has been enabled.
Hello, my name is Nadine Mazard. I am an attorney admitted in other jurisdictions. First, I want to address something that Tara Clark mentioned in the previous meeting, which is the fact that you are not going to be including a site in Orange County. Right now, you only have a site in Pasadena, Ontario, Galen, USC, which was recently added. Again, these are all places that are a distance from Orange County, and I think Orange County needs to be represented. And in fact, I did a Google search, and since 2008, Anaheim has been represented. I see that it is being used for accommodations. I do think there are other hotels. You could even reach out to Cal State Fullerton, UCI, other options to be able to have as a site location, and simply to cut off to with the distance. I do think, again, Orange County will be represented. I do know that there was something stated that only 4,000 people had applied, but typically in July, there's going to be close to probably 8,000, 7,000 applicants that will eventually come there. And I do also know that other individuals from February 2025 will eventually cash in on their waiver and increase. And so that will be at least 1,000 more people that will waive in. And I do think that we need to have more typing spots everywhere, just besides Ontario. And again, opening up the Orange counties to be able to have that. I am going to also stand that attorneys should be able to waive in You are one of the only jurisdictions that do not allow attorneys to waive in. And if attorneys can't just waive in, there should only be a state-specific exam, and the state-specific exam should tell you exactly what you need to study, to know, and to learn to be able to, that makes any sort of difference than other jurisdictions. Lastly, the cost should not be raised with regards to the amount of money that people have to spend. And also to please do not use Kaplan.
Next on the sign up list, we do have Henri Marini. Your mic has been enabled.
Good morning. I want to talk about a issue known as Marcy's Law. Under Marcy's Law, victims of crimes, especially when the victims are children, are entitled to due process whereby prosecutors follow up with the victims prior to the entering of a plea deal for simply conferring with the victims on whether the deal being on the table is okay, and to give them the opportunity before the deal is entered to submit a victim impact statement in open court and have their grievances be openly heard, their wishes be openly heard, and what they wish for the outcome of the case to be. Now, it is very clear Marcy's Law does not state that prosecutors have to abide by those wishes, but they must, in fact, have that hearing before the deal is entered. And when a deal is entered, the deal must be entered accurately in that it was represented before the entering of the deal. When that does not happen, we have a Jeffrey Epstein situation where basically prosecutors violate a victim's constitutional rights, and in this case for state charges, violate the California state constitution and enter an illegal plea deal that's known as prosecutorial misconduct. And exactly that very same issue happened here on case 24 CJC M07073-01. And in fact, on February 18th, 2026, the child victims of that case came forward, submitted a complaint in open court before Judge Sharon Cooley in the Clara Shortridge Criminal Court building in Los Angeles, and complained that prosecutors did just that. This is an issue. We have a presiding city attorney, Heidi Feldstein-Soto, through her deputies and herself, openly violating a child victim's constitutional rights to due process, and still submitted that plea deal knowingly and in writing.
Included. Next, we have Audit LA, who I do not see in the attendee poll list. Next, we have Benjamin Cohn. Your mic has been enabled.
Hello. I want to urge you to take the second chance that you carved out for yourselves when you wisely deferred to this meeting or to subsequent meetings over time, and not in deciding in January under an accelerated time scale the issue of what notice to recommend for the multiple choice question vendor on future bar exams. The second chance gives you the opportunity to reassess, I think, some confusion that was relied upon in some of the prior leanings towards going with next gen. I heard statements that it would not be any more expensive, for example, from a trustee at the last meeting. That would only be potentially true if you didn't have to pay for both in order to go for the NCBE, but as you know, you do. The budget Terry, policy that you properly set when you declined to increase the exam fees does not allow for the next gen as an option, and you shouldn't go back on that policy call in order to do next gen. Secondly, there is apparently some confusion as to who should be held responsible for the fact that the trustees didn't get what they thought they were getting in the February 2025 in terms of the number of questions. I appreciate that it would be incredibly frustrating to have relied on 200 answers in order to approve something and then not get it, but that by staff's own admission was not what Kaplan had ever agreed to. So if you thought you had gotten that agreement, it was because your staff didn't negotiate for what you thought they had said they were going to, or what you told them to, and make sure they got it, rather than because the vendor underperformed. And the vendor should not be punished or penalized or held as less reliable because of that. There were some comments by some of the deans that you would, because the pandemic is no longer in its pre-vaccine stage as it was in 2020, be able to claim a fundamental alteration for remote testing in order to abide by NCBE's preference not to allow that to ever be considered as a testing accommodation. And that is not legally relevant to fundamental alteration, which is based on whether the exam as accommodated could measure the intended skills or knowledge that it's designed to, as a matter of theoretical fact, not of whether the vendor is willing to accept compliance requirements or not, and for a chosen vendor. Thank you.
That's concluded. Next, we have Ray Hayden. Your mic has been enabled.
What happened there? Let's see here. Am I there?
Yes, we can hear you.
Okay, I'm really sorry about that. I clicked the unmute and all of a sudden I was looking at another screen. First things first, I'm going to agree with most everything that Benjamin Cohen said. I've been listening to him for a long time, and he's just nailing them out of the park. The other thing is the first speaker, I agree with that California, I would never qualify for this myself, but you should have admission on motion. It shouldn't be a non-issue. There's other requirements in it. It's not just, hey, come on in. But the first girl, I believe she made a really compelling argument for her case, and I was pretty impressed. I got 30 years in litigation support. Now, beyond that, I suggested a long time ago that you go to a multiple choice only question scenario. In California, you have a number of professions that do have multiple choice only licensing exams. It's not that it can't be done. It can be done. And by the way, Kaplan didn't I don't want to say it, but they didn't mess up. Okay, let's put it that way. It was basically an unfortunate situation to happen. That February 2025 exam that was a snafu, if you go back and analyze it and look at it step by step, purpose for purpose, I'm telling you, as somebody who watched the whole thing happen, fall apart and everything else, I watch it. You were so close to nailing it out of the park with that exam. February 2025 was almost a slam dunk win for California Bar. I'm telling you, I know. Okay, so here's the deal. The multiple choice question program that I suggested includes exams. It also includes internalizing the information that will protect the general public, guarantee more competent attorneys, and absolutely rock solid guarantee a more diverse California Bar membership. California Bar has not only contacted me once or twice or three times, they've contacted me a number of times to ask me for my suggestions and information. I submit information on a constant, persistent basis. I hope that you actually get it, and I hope that you actually look at it. Because if you look at it carefully, years later, you'll know I was right. Thank you very much.
Public comment. Next, we have Jules Sarkar. Your mic has been enabled.
Good morning. My name is Jules Sarkar. I'm calling in today to join 62 bar associations, which have sent you a letter asking you to oppose contracting with the NCBE and to adopt their new exam. I see that there have been some amendments to the draft report. I thank this board and committee for looking at it thoroughly and removing some of the inaccurate information that it is used to promote the NCBE's product. But I joined these 62 bar associations, which represent legal professionals from all sectors across the state to not move forward with the NCBE. As you know, the Supreme Court has issued a very precise order that will require examination of topics that are not covered by the NCBE's exam. So in either scenario, the state bar will be required to develop its own exam. I urge this committee, this board and this committee, to include in its report to the legislature information that has already been they've already received testimony from the state bar's former executive director as to the millions of dollars after the early termination fees with Kaplan that they would have to pay for contracting with the NCBE, and to also include other numbers that it has provided in the past as to the cost of renting venue spaces instead of providing remote exams. And developing this exam in addition to the exam it will have to develop anyway to comply with the Supreme Court, so that our legislature is satisfied with its request for risk-benefit analysis. It really needs to see those numbers. Some of those numbers have already been provided to the legislature. I urge you to continue revising this report and to show that. Thank you very much.
Thank you for your public comment. Chair Cisneros, I do not see any more raised hands in the attendee pool list.
Thank you very much, Sharon. Thank you for handling public comment. Next on the item is Chair of the Board of Trustees report. I have nothing to report at this time, and I turn it over to Alan.
Now, yeah. Sorry about that. Chair's report. We previously gave a chair's report in the main meeting or in the committee meeting, and I have nothing to add at this time. So, Jose, I'm going to send it back to you.
Thank you, Alan. Next on the agenda is the consent item, action on addendum to the Committee of Bar Examiners Refund of Fees Policy. First, ask if any member wishes to pull this item off the consent calendar.
Please. Seeing none on the committee.
And seeing none on the board. So with that, I think, Alan, you want to ask for a motion in a second?
Yeah, I'll ask for a motion for the Committee of Bar Examiners to approve this consent item.
So move.
Ooh, I'm sorry.
I was second that motion.
It was
Kareem Gangora made the motion.
Kareem Gangora moved. Michael Cow seconded. Devin, please call the roll.
Bolton.
Yes.
Burns. Not present. Cow.
Yes.
Gangora.
Yes.
Kaplan.
Yes.
Kramer.
Yes.
Lawrence.
Yes.
Lee.
Yes.
Macy Walla.
Yes.
Montgomery. Not present. Reed.
Yes.
Reyes.
Yes.
Reyna.
Yes.
Silva Guzman.
She stepped out.
She stepped out.
Not present. Smith.
Yes.
Yokelson.
Yes.
With 13 ayes and 0 nays, the motion carries.
Jose?
Thank you very much. I'll ask for a motion and a second from the Board of Trustees.
I'll make the motion.
Second. Thank you very much. Motion by Trustee Harrison, second by Trustee Stevens. Vote, please.
Barahona,
Aye.
Buenaventura, not present. Good.
Aye.
Gore,
Aye.
Grande,
Aye.
Harrison,
Aye.
Huser,
Aye.
Giorgiello, not present. Soel, not present. Stevens,
Aye.
Tony,
Aye.
Cisneros.
Aye.
With 9 ayes and 0 nays, the motion carries.
Thank you very much. Alan, over to you.
Thank you. Next on the agenda is the discussion of the draft risk-benefit analysis regarding future bar exam options. This analysis has been prepared in compliance with the requirements of the California Rule of Court 9.6 sub B and also California Business Profession Code section 6046.2. This item is being presented by Chief of Admissions Donna Herskowitz and Office of Admissions Director Cody Hunanian. Also present with us will be the Office of Admissions Consultants, Dr. Danette McKinley and Dr. Louise Berry. I want to note for our participants and for the public that the focus of this item is feedback on the risk-benefit analysis. The goal is to provide staff direction to finalize this report for adoption by the committee and the board at their April and May meetings respectively. The board and the committee are not required to take action today to select the final recommendation for the Supreme Court's consideration, and as a result, the staff report before you does not include any proposed resolutions. So with that, Donna?
Thank you. Cody, if you can share the PowerPoint. And Sharon, if you can just make sure that Dr. McKinley and Dr. Bari have been promoted.
See them in.
Thank you, Cody. Next slide, please. So today, as Chair Yokelson said, we are here for a discussion of the risk-benefit analysis, the draft of which is attached to this staff report. Just wanted to give you a quick roadmap of what we're going to go through as the lead up to getting your feedback on that risk-benefit analysis. The plan first is just a reminder of the requirements of Rule 9.6b of the California Rules of Court that details what needs to be included in that risk-benefit analysis. We are going to turn quickly to a discussion of the requirements of Business and Professions Code 6046.2, which aligns nicely with the requirements for the risk-benefit analysis, and there's a section included in the analysis which specifically addresses those requirements. Then, just to make sure that everybody's on the same page, we want to just do a quick overview of the direction that was provided by the board and CBE at our last joint meeting on January 23rd. At that point, after I finish sort of those introductory remarks, Cody is going to lead you through a discussion of the framework for decision-making on this critically important topic. Then I'm going to turn to the cost section of the risk-benefit analysis. This section was added to the risk-benefit analysis yesterday, and I want to just go through that section with you all, as it was not something that you had previously had the opportunity to discuss as we were continuing to finalize that. And then we wanted to turn to a discussion of if there's any further information that you believe is needed for the final risk-benefit analysis, a discussion of any suggested revisions that you have for us to make between now and the Committee of Bar Examiners April meeting and the board's then May meeting for final adoption of this analysis. Slide, please. So let's start with a quick review of the requirements of the California Rules of Court, Rule 9.6b, to conduct a cost-benefit analysis, or as we've renamed it, a risk-benefit analysis. The purpose of trying to avoid that feedback.
Does somebody's not muted on their personal computer?
Let's try that again. So the purpose of the renaming is, as you all have discussed on many occasions, although cost is, of course, a very important factor, it is not the driving factor. And although cost-benefit analysis is certainly a term of art, you had requested that we not put an implication out there that that cost is the driving factor, and so we're referring to this as a risk-benefit analysis and really using that as part of our framework. So the requirements for what needs to be included in this analysis, specifically, the Rule of Court requires that if for any changes to the bar exam that require substantial modification to the training or preparation required for passage, or changes that substantially modify the method by which the exam is administered, we need to complete a cost-benefit analysis, which includes any of the following bullet points which are relevant in that particular case. Those include direct and indirect costs and tangible and intangible benefits, alternative existing products or services that can accomplish the same goals or objectives at a comparable or lower cost, whether technological requirements or new fees to implement the proposed changes would place an undue financial burden on examinees, estimated number of temporary and non-temporary full-time staff positions that would be necessary to implement the changes, time frame estimated to competently implement the proposed changes, and whether the proposed changes have previously demonstrated efficacy under testing conditions similar to a bar examination. We do actually talk to each of those components in the risk-benefit analysis that is included as Attachment A, but I do want to circle back to the if relevant part of that lead in here that says that only the relevant items need to be included, in case there's a question of what on earth is that about. So this requirement, as we said, would include changes to the bar exam that require modification in the method by which the exam is administered. And so that could be going to a remote administration. Or other similar changes that are not the creation of a new exam. And so there are items here that talk about, for example, whether proposed changes have previously demonstrated efficacy on testing conditions similar to a bar exam. Well, there's no existing exam anything we go to is new. Next Gen has not yet been tested. And so there's certainly very strong arguments to be made that some of these items we wouldn't need to include in the cost-benefit analysis. Are there alternative existing products or services that can accomplish the same goals or objectives? There aren't existing products. However, we think it's important to talk about the options that the board and CBE are considering and the goals that each of those meet. And so we do talk up to each of these in the analysis, but we just wanted to highlight that's some of the reasons why we spend more time on some of the items in the risk-benefit analysis than on other items. Next slide. So in addition to the requirements of the California Rules of Court, there's also a requirement under Business and Professions Code 6046.2, which requires the Committee of Bar Examiners to develop a report, submit to the Board of Trustees, the Chief Justice, and the Assembly and Senate Judiciary Committees on whether adopting a uniform bar exam would be more efficient to administer and whether adopting a uniform bar exam would lower the cost of the administration for the state bar and the examinees. As I said, this aligns well with the requirements under the Rule of Court, and we have incorporated this within the attachment to today's item. Next slide. So Cody and I wanted to circle back for just a minute to remind everybody of the direction that was given to us at the January 23rd meeting. The final direction from the board was that we explore two recommendations for further research and review. Those two recommendations that we were directed to review were adopting Next Gen without a California component, and that had actually been CBE's sole recommendation that we move forward with the Next Gen without a California component. The board, not ready to narrow in on a single solution, said in addition to that, we should be doing some further research on review on a recommendation that would have us revert back to the Kaplan questions in 2028, because that would allow time for us to evaluate whether the software platform that is being used for the Next Gen uniform bar exam is able to handle the capacity of all of the test takers who would be adding on at by the July 2028 exam, and it would allow us to review performance data to determine whether whether NextGen UBE aligns with California's guiding principles. It would allow us to, for example, assuming this information were available from the states, look at the performance and see if there are some populations that where there's disparate performance to a greater extent than there's disparate performance on the exam that we administer. It would allow us time to make those determinations and to consider any further information, such as state bar capacity or other information at that time. So that option really would have us revert to Kaplan questions for 2028, and then start assessing the results of NCBE's NextGen based on the 5 administrations that they do: July 26, February 27, July 27, February 28, July 28. Do an analysis of the information that we have at that point, develop a recommendation, which would then be presented to the court, ideally by July of 29, so that we could give 2-year notice at that juncture. Next slide. And so before getting to the draft risk-benefit analysis itself, Cody's going to walk you through a decision-making framework that we touched on a little bit at the January meeting, but really wanted to hone in on it a little bit with you all.
Yeah, thank you so much, Donna. Over the course of many meetings now, you've reviewed a substantial amount of information. We've brought to you a number of different frameworks and kind of decision-making organizational structures to support these discussions. And as Donna just suggested, we wanted to return to what we think is maybe the most concise and kind of simplest framework that we've previously discussed, and one that I think is particularly useful now that there are 2 options currently under consideration. And the central question of that framework is simple. What is it that you are prioritizing? Is it control, or is it stability and predictability? And so I want to go through our 2 options here and kind of pluck out of the risk-benefit analysis some of the relevant examples that fit this framework and can help us think about things in this framework. So under the use of Kaplan model, you are prioritizing control. That means control over the exam design and content map. At least initially, this means retaining the current structure of the exam and continuing to test the current subject areas, but it preserves the State Bar's authority to make future decisions absent of a completely new California exam. This means control over equity initiatives. This means retaining the ability to develop California-specifically tailored solutions to equity matters. I don't think there's a particular initiative considered at this time, but I know that trustees and members have expressed this as an important area worth future discussion. It means control over administration flexibility in the future, and we've talked a lot about remote testing and more frequent exam administrations. It means control over information sharing and stakeholder engagement. We note in the draft analysis amongst some of the benefits to the State Bar that under this model, the State Bar has more flexibility to share information about the exam development process and to hear directly from stakeholders and actually respond to their feedback when it comes to exam development and design decision making. However, the flip side of this greater control, it also means accepting greater risk. And I want to point out some of the risks that we've identified in the draft report, but among them are technology and administration risks. Under the use of Kaplan model, the State Bar is responsible for procuring and managing the exam software vendors, which means assuming responsibility for any technological performance and administration failures. It means accepting greater risk when it comes to stakeholder confidence. We've heard, particularly in our last meeting, directly from some stakeholders, including our ABA law school deans who were at the last meeting, who expressed really serious concerns about the State Bar's ability to develop its own exam. This also includes content development risks. Some of the risks related to developing the exam content can be mitigated. We have been working to enhance our content validation process. We've been working to recruit our content validation panelists and subject matter experts. But there are other challenges, such as the limited number of study questions or questions that would be available in a study guide that are risks that really can't be addressed. That is an example of something that is limited by just the reality of the materials that will be produced and that are available to us. And then lastly, it means accepting greater reputational risk. Exam development or administration problems really can lead to negative impacts to the credibility of the bar exam as a tool to measure minimum competency and its importance to public protection. It also, and this was something that was raised by some of our stakeholder discussions, could just more broadly affect trust in the state bar as an institution at a time where there's greater distrust in institutions more broadly. So these are a few of the examples that are included in our risk-benefit analysis that really fit in this framework. Now, turning to option 2, adopting the next-gen UBE, moving forward with this approach really prioritizes stability and predictability. The stability and predictability of the next-gen UBE is largely the result of their multi-year national development and implementation process. This has included pilot testing of draft items in 2022, publication of their content outlines in 2023, publication of sample questions and study materials starting in 2023, and field testing and prototype exams and beta tests that occurred in 2024 and 2026. Stability and predictability also stems from the fact that the next-gen UBE is a nationally validated exam. The content's based on analysis of the knowledge and skills required for competent entry-level legal practice nationwide. The development process included input from legal educators, practitioners, and assessment experts across the country. And before the launch of this exam, the exam will have been tested by more than 10,000 students nationwide. For examinees, predictability is also supported by the robust bar preparation market that will be available for the next-gen UBE. There are a number of test preparation companies already producing materials and practice questions, and this is something that will likely not, at least initially, be available to students if we pursue option 1 outside of the smaller study guide that we anticipate launching. In addition, the NCB is invested in user experience expertise and platform testing, which contributes to a more predictable testing experience for examinees. And finally, I think stability as it relates to our stakeholder perception is largely supported by the fact that we have heard from our stakeholders that there's a lack of confidence in our ability to develop our own exam, or at least for some greater confidence in the NCB's ability to develop the next-gen UBE. And so stability from a standpoint of our stakeholders' perception of the exam and its strength moving forward, I think is benefited from this option. Just like with greater control came greater risk, choosing this option with greater stability and predictability also means that you are selecting to relinquish some decision-making authority. And we identify some of these challenges in the draft report, but this means relinquishing control over exam design and content map, while the state bar could still explore a new California-specific exam in the long term. Adopting the UBE means accepting the new design, elimination of traditional essays, the inclusion of more performance-based questions, work performance tasks, and the introduction of the new integrated question sets. It means relinquishing flexibility over exam administration. That means losing the ability to independently develop remote testing or more frequent exam administration. It means relinquishing opportunities for California-specific equity initiatives. It means relinquishing control over applicant fees to some extent. Under the next-gen UBE, the technology fees are paid directly to the NCBE, while the board still retains authority over other exam and application fees. And really it also means relinquishing some authority to respond directly to exam issues. In such situations where exam issues have required corrective action, Under this option, the State Bar would largely rely on the NCB and its expertise in addressing some of those matters. And again, I just want to keep pointing out that this is a selection of some of the benefits and risks that are found in the draft report, but these fit under this model. Now, I just want to add some important nuance to these trade-offs as well, because they aren't entirely black and white. First, greater control doesn't necessarily mean new outcomes. Remote exams, for example, even if the state retains the ability to explore remote exams or more frequent administration, those options may ultimately prove infeasible due to technology limitations or the size of our item bank. Second, some risks can be mitigated. We've been working, as I mentioned, to improve our content validation process, working to improve our exam software procurement process, and we've already begun engaging our stakeholders in more enhanced ways with the quarterly law school dean meeting and our roundtable discussion at the last meeting. It is possible that that engagement can address some of the stakeholder concerns. And lastly, relinquishing decision-making authority may actually be appropriate in areas where NCB's expertise is valuable. I mentioned relinquishing control over exam design and content, but the Next Gen UB introduces new exam design and content changes that emphasize assessing practical skills, which aligns with the State Bar's own priorities. I mentioned relinquishing control over possible remote administration in the future, but perhaps NCB's cautious approach to evaluating remote testing actually relieves the State Bar of the burden of independently solving this complex technological and security challenge. And lastly, relinquishing control over equity initiatives. While that is a concern, equity considerations are part of the Next Gen UBE's development process, and we've seen that the NCB employed user experience experts to address accessibility concerns when they designed the platform. So I want to add this nuance just to suggest that while there are these simple trade-offs, control versus risk, stability and predictability versus control, that there's a level of nuance and considerations for each. With that, I think we want to pause and open the floor to discussion to give trustees and committee members an opportunity to discuss these options further.
Thank you. Thank you, Cody. Cody, question. Who grades, who is the grader on the NBE? Is it the local state or, individual state?
Yeah, jurisdictions will still recruit graders. The NCB provides a platform for them to use, and along with some of the materials that graders use when they're, rubrics and some of the materials that are used for grading purposes.
So that expense is still there?
Yes.
The expense for the graders. Okay. Members of the Board of Trustees, questions or comments?
And again, we'll be turning to the cost section after this, but we did want to just give you an opportunity, to talk about what we've already presented, so that we don't cut off your thought process on that.
Yeah, there's a lot to consider here. Are there questions or comments? Oh, I'm sorry, Trustee User, I'm sorry.
That's okay. Well, thank you. I think all of these presentations were incredibly helpful. I just had one question just for my clarification, because these terms are sometimes so hard. The NCB without the California component is the recommendation that was presented by the California deans in all of the different areas at the January meeting. Is that correct? Am I using the right term?
That is correct. The ABA deans clearly recommended California. I'm sorry, Next Gen without the California component. That was also recommended by the deans of the California accredited law schools. And although their survey results, the survey results of the unaccredited law schools pointed elsewhere, at least one of the two deans who were presenting in January from the unaccredited schools said he was now convinced that that was the way to go as well, and has submitted public comment on that point.
Great, thank you. And was that that solution, the next gen without the California component, also the one used in 48 other states?
48 other jurisdictions have adopted Next Gen, and some of them will have a local component, and some of them will not. I apologize, I don't have that count off the top of my head. I can probably get that while we are talking, how many of them are adopting a local component and how many are not.
Thank you.
Other questions or comments?
From CBE members as well?
Yeah, go ahead, Paul.
To clarify then, the NCBE will be providing the calibration services among the graders of essays. That's my assumption, if somebody can confirm that. And I presume that also that calibration will not just be among the California graders, but with graders in the other jurisdictions that are grading the same essays.
That is the way it was explained at the conference, NCB's conference back in May in Seattle.
Yeah, because that'll be important, because we might at some point be considering scores that are graded by other jurisdictions.
Exactly.
Well, so California graders will grade California exams. The rubrics will be provided by NCBE. The platform will be provided by NCBE. They will do the psychometrics and the scoring of that. They'll do the calibration. So it's not that California exams will be graded by people from other states, but rather, like the MBE builds in scores from national scores, there will be, they're calibrating to the same, in the same way based on the rubrics. But this will be California. We are responsible for recruiting our graders and providing our graders. The grading policies would be adopted by NCBE, and there are currently two policies that they are evaluating. Right now, NCBE will require for Next Gen that all of the written questions, i.e. not the multiple choice questions, all of them go through two reads. There will be two graders reading all of those questions and grading them. And they are evaluating a reconciliation process for any differences, where those two graders get together and figure out what's different between their two scores, and they come to a consensus on that, or a process where you have a basically like the EDGE team member would look where there's a difference and make a decision. Will do their own score that determines which of the scores is the score that should count. So that's one of the policies that they are evaluating, and they part of how they're evaluating that as well. And they just completed the grading for the from the beta test that happened in January. They tested both of those models. And so when they get the data, they'll be evaluating the data from both of those models. They had some focus groups with the graders, and I'm assuming that they got some input on those different models. We had probably 15 of our California graders who participated in that grading of the beta test. And so one of my next steps is for us to have our own focus group with those 15 graders and get their input on what that was like. And so we can get more information from them on grading to the rubrics that NCB provided, the amount of time that it took, because grading everything twice sounds like it's going to take a lot longer, but because some of the answers are one sentence answers and not, a multi-page essay answer, the NCB's original research suggested that it wouldn't take any longer. So we want to get that information too on the time it would take to grade and the number of graders that it would take.
Okay, what I was trying to address was the degree of confidence we can have in somebody's score that they bring to us that was a result of grading in another next-gen jurisdiction.
Yeah, I raised that exact issue at the conference, and the assurances were at that time that everybody nationally would be calibrated. Now, we'll have to see how that plays out.
Okay, thanks.
Anybody else?
Hi, this is Julie from Committee of Bar Examiners. Can you hear me?
Yes.
Okay, thanks, Alan. I just had a couple questions. It says that NCBE will be providing raw and scaled scores. So are we required then to use their scaled scores, or could California choose to take the raw scores and do our own scaling?
No, we would not be able to do that. They are doing the scaled scores. They're providing both for our analysis for the analysis purposes of the jurisdictions.
Thanks. And then I had some concerns. I think from the beta test, it said that 73% of graders said calibration was sufficient, and 62% said that reconciliation was sufficient. And those numbers seem kind of low to me. So I was wondering what the NCB is doing to address those concerns.
Yeah, so those are preliminary numbers. I got them last Friday. They came out last Friday, so they are. We haven't had time to follow up on that information, but we will certainly do that to get more information about that. But I mean, I think sort of to the extent that there is a feeling that if they interpret those results to say that the information that graders were given was not sufficient, then that's just sending a message to them that they need to put more training into the process before sending people off to grade. I think for some, maybe the specific rubrics were different than the rubrics that graders have used in certain jurisdictions, and just getting some more training on how that's going to work. And how the platform works, all of that. I think there are opportunities there to improve the training that is provided to the graders to make sure that there is a strong sense of satisfaction and a strong sense that the information they have gave them everything that they needed to effectively grade. But we will follow up specifically with NCB on that question, Julie.
All right, thanks. Yeah, I want to make sure, is it more of a question of training, or are there structural issues that need to be addressed by NCB? Thanks, Donna.
It's a great question, and something we are going to have to really think about. Who else? Anybody? Seeing none, Cody or Donna?
Cody, if you can put the PowerPoint back up. Oh, there's a hand.
I'm sorry, I missed the hand. Who's?
Hi, this is Patty. I just had a quick question. Can you just break down the fees on both of these options just again for me?
So we're just about to actually go through that.
Okay,
so
perfect.
You're perfect.
I don't always see hands up here, so if I'm missing anybody else? No. Go ahead, Donna.
Cody? Just a reminder of what we're looking at in this cost analysis and what we're not looking at, most importantly. As we talked about at the beginning, as you all know, we left here in January with two options, the first being use of Kaplan. It's important to understand that we're all on the same page, that use of Kaplan does not make a decision about the future bar exam. It really is a way to defer the decision until we have more information. So as a result, the analysis of costs of this option, of this use of Kaplan option, is the analysis of specifically a California exam with Kaplan developed multiple choice questions and the essay and performance tests in our bank, and the ones that are being developed by Kaplan. It is not a cost analysis of a newly created California exam in line with the parameters that were initially adopted by the court in their order of October 2024. So I just want to be crystal clear about that. This is reverting back to the Kaplan questions in 2028 until such time as the board and the committee and the court make a final future decision for the bar exam. Additionally, what is not included in this, or what impacts the analysis here, is staff does not believe that it's realistic to assume within the window of this period when we would be in the use of Kaplan, we don't believe that it is realistic to assume that a remote administration would be possible. Nor do we believe that the size of the item banks will be sufficiently robust in the next several years to allow us to move from the larger convention centers, hotels, and arenas to small test centers. So the analysis does not take into consideration the possibility of cost savings or what magnitude those could be, small or large, from those kinds of changes in the administration of the exam. So we really are comparing a fully in-person administration to a fully in-person administration. Next slide. And let's see how big you can make this. Thank you. So what these slides are is just cutting from what is in the risk-benefit analysis, pages 23 to 30 in the risk-benefit analysis, just lifting that chart out and putting it here in the next several slides. So I just want to be clear about that so you can follow along on the slides, or you can follow along in the risk-benefit analysis itself. You will see that I have included some comments about the costs that we are currently incurring, as well as the costs that we are estimating under option 1, the use of Kaplan, or option 2, adopting the next gen UBE. I don't want to go through all of this because that would be time consuming and tedious, but just a couple of highlights here. In the first line under item development as part of our exam development and validation section, I just want to explain sort of what we have here and what we don't have here. So we do, as I note here, that the current amount, that $2.85 million, assumes continued payment on the Kaplan contract. It does not reflect the costs that have already been paid for years 1 and 2 of that Kaplan contract, and it also doesn't reflect the year 3 costs of that contract, which would be paid between this coming August and March of 2027. It's reflecting sort of the key difference between the two options. Potentially could be, if we continue the use of Kaplan, then we would pay the $2.85 million for years 4 and 5 of the contract. If the decision were to adopt the next gen UBE, we have the option, in lieu of paying that year 4 and year 5 amounts in the contract, of paying $712,000 as an early termination penalty. And as we had mentioned before, we have engaged, we've asked Kaplan to talk with us about whether there are opportunities that for renegotiating that early termination penalty. If, for example, Kaplan, giving the questions back to Kaplan that they had provided to us, might be consideration, or giving some number of those might be consideration for elimination of that early termination penalty, and a variety of other factors. And so we'll be engaging with them on that should the decision be made to adopt next gen and not go forward with the Kaplan questions. Also, here, right, and again, the key difference, right, is that with the Kaplan question, with use of Kaplan, we need to continue developing our own exams. So we've got exam development costs. We've got all of the content validation and subject matter expert review costs that we must continue to pay. If we were to adopt next gen, they are doing, without a California component, they are handling the development of all the items. They're handling the validation of all of the items. We don't need any exam development software. What we would need to do is pay them, instead of the $72 per licensee that we pay for the MBE, we would be paying $145 per licensee for all of NextGen. I do just want to note, and we'll get to this at the very bottom of the chart, that is part of the fee. Applicants also pay $149 directly to NCBE as part of the tech fee. I just didn't want to ignore that piece. On the next slide, we will move to exam administration costs. Before I do that, are there any questions on this exam development cost implications?
We also have a tech fee, don't we, on the existing exam?
Yes, but it is ultimately part of the application. It's fee that we charge, right? So we charge an 800 plus 877, I think now, fee for non-attorneys to take the exam, plus the $153 laptop fee. But that ultimately gets rolled into what we charge them. And what we charge applicants is a combination of all of these things: the exam development costs, the exam administration costs, the costs of staff that relate to the exam work. All of that adds up to what that fee is. Each of those elements goes into that cost, and would continue to go into that cost. So it isn't, I want to be crystal clear, just because we would be getting charged $145 per applicant, that is not what the bar application fee would be for applicants, because it would need to cover costs of exam administration, costs of staff that relate to the bar exam, and the other items that are laid out here. So I do want to be clear about that.
Okay, yeah, I guess only the bottom line numbers really matter.
Yeah.
Not the details. Thanks.
Trustee Tony?
Thank you. Donna, here's the question I have when I'm looking at this. Could you tell us what is the cost of the Kaplan contract, the total cost, if we continue through year 5? And what is the cost if we exercise the early termination option?
So the total cost, let me turn my pages here. The total cost of the Kaplan contract, years 1 through 5 total, is $8.25 million.
Okay.
If we, somebody can pull out a calculator, I'm going to give you numbers. If we terminate after year 3, then we would be eliminating $2.85 million from that. So 8.25 minus 2.85. But we would have a $712,000 early termination penalty. I'm sorry, there was a part of that comparison that I think I missed.
No, I was just wondering, because I couldn't see it when I read this. I didn't know where to find it. What the amount is, what's the delta between the two?
So, quick math, it appears that, so the 5-year contract, as I said, is $8.25 million. If we terminated after 3 years, but did have to pay the early termination penalty, it looks like we would be paying $6.1 million, I think is the math on that.
Thank you.
Let's move on to the next slide, Cody.
I have a question about this too. Can we go back to the last slide? So I'm looking at this next gen option, but there's a lot of qualifiers here. It says it doesn't include this fee or that fee, like you did for Kaplan. Can you just say what the total cost is if we go to next gen?
So I'm not sure on the exam development and validation. I'm not sure what you're pointing to that.
So in the comments, it says early termination penalty does not include year 3 costs of 1.65. And then here in the next column, option 2, it's just confusing to me. I just want to know the actual, like, the cost, the total. I'm trying to weigh the cost of going to next gen and terminating early our agreement with Kaplan. And I'm not able to do that with these numbers.
Yeah, so I think the key number is the difference between the two, right? Is if we continued for the full 5 years of our contract versus getting out of the contract after 3 years and paying the early termination penalty, it's a difference of $2.1 million.
Right.
Okay.
I think the answer to your question is on page 30.
Okay, thank you.
Can someone just direct us to what that answer is? Because I had the same question.
So at the end of this, there is a total difference at the end of this chart. There are some caveats that I do want to talk to you about because there are some things that haven't been included, some of which require further research, some of which we can't necessarily include. But I do want to, I'd like to take you through that caveat. But at the very end of this, we list what the total cost would be for the item development, exam administration, staffing under each Kaplan and NextGen. What you can do, and that includes the difference of years 4 and 5 of the Kaplan contract versus only the early termination penalty. So those are included in this total. What is not included is the what did I say the amount was that has already been paid? The amount that's already been paid hasn't been included. That amount would be the same though under either of these options. And so what that shows is use of Kaplan annual costs of $7.586 million with a one-time cost of the 2.8 one time. This is sort of in air quotes because it's over the course of a period, but with that $2.85 million in the contract costs. For NextGen, instead of 17.586, it's 16 million with the one-time cost of the $712,000 early termination penalty.
So it looks like this is saying that it would be cheaper to go with NextGen over time. Is that a false conclusion?
That is what it says. This is why, though, I do want to go through some of the caveats. We need to do some more research on the grading to make sure. Right now, I've used the same cost for grading for both of the options. I need to confirm what we think the likelihood is of would we need more graders? things like that. I need to develop that. But there are also a number of things that aren't included that would further reduce the cost of next gen. And so I did just want to talk through some of that as we turn to the exam administration section.
Okay.
Question from Trustee Grande.
Yeah, I think one thing that would be helpful, I don't know, can you hear me?
Yes.
Okay, one thing that would be helpful for me is if we could do, if there could just be like a table that shows this is what the cost would be in 2027 with option one, option two, this is what it would be in 2028, like that, just because I get the sense that all the data is here, but it's visually hard to see it. So I don't know if we could get something like that once you take into account these additional factors that you're mentioning for our next meeting.
Yeah, we will certainly look at any possible way to make this more sort of easily apparent what it is showing. One of the things, though, that I do want to be clear that is set forth in the narrative in the report is that you cannot take this and say what the applicant fee is going to be for either of these options. There are a number of things that we haven't projected escalated costs. So we are using the cost of staff compensation for 2026 based on the fee analysis that you all saw in November of 2025. We didn't escalate that for any agreed upon or future cost of living adjustments or merit increases. We didn't escalate by the CPI or anything else the cost of test sites. So we're doing an apples to apples comparison between option one and option two for those things like test sites and staff. But it doesn't allow you to then do the math and say, well, what does that mean the applicant fee is going to be? And I just wanted to be crystal clear about that. But yes, we will continue to work on the visuals on this. And there are a lot of people that I am working with who have a much better visual eye than I, who can help us pull that together.
Perfect. And I just had one other question. So historically, for the NCBE, have their license, the license per participant, has that gone up year to year? Does it happen every 5 years?
It's not year to year. I can probably pull a history of that to find out. As I mentioned in the staff report, we did when we spoke with NCBE. We had asked that question about what's the likelihood of that fee, the $145 per applicant that would get charged to the state bar. What's the likelihood of that changing after July 2028? Unfortunately, as part of our conversation, we really ended up focusing on the tech fee that's charged to the applicant, which we talked about sort of the likelihood of that potentially decreasing over time. But because our conversation veered away from the fee that we would pay, I don't have an answer to that question, so we can certainly circle back with them. That was, I just want to be clear, that was based on sort of the flow of the conversation. There was no avoidance on their part of answering that question.
Thank you.
So looking at the exam administration costs, again, a lot of numbers here, a lot of information. The costs are identical, with one exception I'll get to. Identical. The costs that are on this document are identical for option one, use of Kaplan, and option two, adopt next gen, with the exception of adding in the cost for internet, and this really is a guess. We estimated $10,000 per site for July and February. I think overall that is high. My understanding is that as NCBE has been working with jurisdictions, looking at the sites that they have, a number of sites already have sufficient internet at the hotels or the convention centers. Some do not. We've had preliminary conversations with some internet providers, and we just need to finalize those conversations. What is not included in that line of all the things about test sites that would lower the cost for adopting NextGen, because it is a shorter exam, it's 1.5 days as opposed to two days. At our testing accommodation sites, where you might have people who are testing for double time, at a 1.5-day exam is 3 days, whereas double time for our 2-day exam is 4 days. So there could be lower costs for the TA sites, for the sites themselves and everything that's related to the sites. There could also there is also the option potentially for fewer sites. We currently, our setup is 2 people per 8-foot table. The NCB requires 2 people per 6-foot table with an exam that is all computer-based, and you don't have question books in front of you. You don't have a series of highlighters and pens and erasers and all of that in front of you. 2 people per 6-foot table is something that can reasonably be accommodated, and so we could potentially get more people in per site, and therefore have to contract with fewer sites. So those are some things that are not calculated in, and frankly, I don't think we'll be able to be calculated in. But we will be clear in the narrative about those additional possible savings. Also, on that front is for the line of proctors and off-duty officers, you'll see that the adoption of NextGen has a significantly reduced cost for proctors. And that's because the proctor to applicant ratio, we currently use a 1 proctor to 30 applicant ratio for our floor proctors. NCBE allows a 1 to 50 proctor to applicant ratio, and they anticipate that after July of 2028, that would actually allow even 1 proctor per more than 50 applicants. And that's as a result of the fact that it is a computer-based exam. The responsibilities of the floor proctors are significantly less. Having observed the beta test, that was certainly my observation, that a single proctor could handle a lot more people than they can currently with a computer-based exam. And so that's part of that reduction. We assumed, for the purposes of this calculation, I assumed just going from 1 to 30 to 1 to 50. I didn't assume anything greater than that. If it is greater, there would be an additional reduction. Plus, there will be a significant reduction in the number of workroom proctors that are required. Again, that has to do with the elimination of paper. And the quality check process is very different. And so I very conservatively reduced the percentage of workroom proctors for this calculation, and so it could be lower than that. Just for a point of reference, in a July exam, in the last July exam, we had about 22% of the proctors were workroom proctors. For the February exam, it was about 9%, and I understand that's sort of the typical difference because the numbers of applicants. We need fewer workroom proctors in February, but we can significantly reduce that. Also, you see reduction in delivery and printing costs. There would be no, the exam administration software cost that is listed here is the 2026 budgeted cost for ExamSoft, and that is what we're using as the assumption for going forward for Kaplan, just for budgeting purposes here, for costing purposes, but that expense we would no longer have if we were to adopt NextGen. Also, I forgot to mention one of the things that could further reduce the proctor cost is that there would also be a reduction in the hours, right? So if we're doing a day and a half exam versus 2-day exam, that would reduce the hours as well. There, with a computer-based exam, there's less what I'm calling pre and post work. Proctors come fairly early in the day before the test takers arrive, and the workroom proctors certainly leave several hours after the test takers leave. And so a lot of that would be able to be eliminated as well. So reduction in hours would also significantly reduce our costs. One of the on the next page, we talk about staff costs. There would also be a significant reduction due to for these same reasons, the reduction in overall hours and the reduction in paper and what that means. So there would be a significant reduction in the overtime costs that we pay staff currently who work the exam. If they are non-exempt staff, they are entitled to overtime. And there's a fair amount of overtime that does get paid, and that could be significantly reduced. But before I move on to staffing and personnel needs, I want to ask if there are any questions on this exam administration piece.
Hi, Donna. It's Julie from the Committee of Bar Examiners. If we go with the Kaplan route, could we have the multiple choice be computer-based as well, instead of having it on printed books and Scantron? Because that would save money as well if we could just have that on laptops too.
Yes, so that is an option, and we would need, under the statute, we would need to give just 4 months' notice for that change. And I think that is something that is fairly easy to make happen. I think there are vendors who are prepared to load the multiple choice questions into the system and have various options for how the applicant engages with the answer, right? Striking through non-answers, selecting the answers. I think there are vendors who have enough experience with this that there are options to do that. If we are talking about, so that would be a savings in printing, a savings in some of the information, because we would not need the Scantron. Right, we wouldn't need the quality control on that piece of it. If we were to try and load the essays and the performance test into the system, that would require a fairly significant, I believe, effort on our part and the vendor to really design that interface to make sure that it is usable for the applicants. One of the things that we've certainly heard when we did the remote exam during COVID, we heard when we did the remote exam in February, or the fully online exam, whether it was remote or not, there were complaints about the amount of real estate, if you will, on the screen when you're looking at the essay. You want to look at the essay and the answer field both, and you want to be able to do that side by side. In February 2025, there was no side-by-side option. The question was on top, the answer was on bottom. It's even more complex with the performance test, which could have 20 to 40 pages of material that you're looking at, and if you have to look at that in one screen and not have access to your answer field or notes field at the same time, that is complex. So that would require, I think, additional staff resources and staff expertise, or at least consultants with expertise in the user interface, user design, to work with the vendor on that. But it is certainly something that, and so that's, I think, noted in the narrative. And so that would be an additional cost if we wanted to load the essays and the performance test in the system. That would be an additional cost for that route. There might be an additional cost with a vendor cost for loading the multiple choice. I would expect there would be a small additional cost on that, but it would be a much more significant cost if we were talking about the essays and the performance test. Other questions on this slide?
Trustee Tony?
Sorry about that. Donna, first, I want to express my appreciation for how thorough this financial analysis is. And I really feel that this is indication of lessons learned from the past, and I can see it in action right now in this report, and that makes me feel really good. I really, really appreciate it. And what I want to point out is what I see here is that the costs that the full comprehensive costs of Kaplan and NextGen are pretty comparable. Okay, I understand that you still need to work on some of it, but I'll just say are generally comparable. And I'm saying that because earlier when we had, we're discussing this, earlier for the remote testing and Kaplan package. It really was presented, at least to the Board of Trustees, that Kaplan would save us so much money, millions and millions and millions of dollars. And I don't see that in this one. And so, I'm not going to ask you to go line item by line item, but big picture, what's different about this assessment than the previous one?
So, big picture, as you said, the prior analyses that you were presented included an estimate of savings that would be attributable to going remote. This analysis does not assume the possibility of going remote, so it doesn't have that in there. But I do want to caution you that you may recall that before the February exam, staff were prepared to come back to you, literally days before the exam. We were prepared to come back to you with an agenda item at the board meeting that requested additional money for the contract with Measure Learning, because the determination was that there was another $2.3 million that would be required to, in order to have the capacity that would be required for the July exam, to have as many to handle the capacity of the applicants. So what I'm trying to say is, the board had originally been given a figure of how much you'd be able to save with remote, and that figure was significantly lessened as conversations continued to happen with Measure Learning, and we were coming back with a revised number. Ultimately, if you look back at that item, you'll see that staff pulled you still have a staff report from that meeting, but staff had said, based on everything that we had concluded at that point, that we could not recommend moving forward at that point with the July exam, and so we didn't have you vote on it. But the savings that we had originally projected for the board to go remote were significantly trimmed down subsequently.
So what we're looking at, thank you very much for that. So the option use of Kaplan is in person. It is not remote. Is that what I understand? Because that's an important clarification for me to understand what I'm looking at, and I'd appreciate that.
Yes, that the option use of Kaplan is based on staff's belief that we cannot say, because again, use of Kaplan is not a permanent decision. It is a decision to defer the decision for a few years. We do not believe that within a few years we would be prepared to say that the technology is there to ensure the security of the exam to go remote. So it does not include remote. nor do we believe that we will have a sufficiently large item bank of questions that would allow us to go to small test centers, because if we go to small test centers, we need to give the exam over a larger window of time because there are not nearly enough seats at test centers at small test centers in California to be able to administer the exam to 8,500 people at the same time. So we would have to deliver it over a period of a week or more, which would require us to have a lot more questions in our bank. So it really is a apples to apples comparison in terms of what the administration is going to look like at in-person sites, convention centers, hotels, et cetera.
Thank you for that clarification. It helps so much.
Should we move on? I apologize, my computer is acting up a little bit. I thought I saw maybe a note about, about a possible break. Chair Cisneros, is that what we're looking for? We're looking for a break?
Yes, we're looking at taking a break in both our locations. A 15-minute break, and then we'll restart again.
Thank you. In Los Angeles, lunch is here. I anticipate this will be a working lunch, so let's take a break, and we'll come back, and just feel free to bring your meals with you.
Thank you, Alan, and same in San Francisco. Folks can grab a lunch.
Live and recording.
Hello, Alan. We're ready in San Francisco.
Okay. Thank you, Jose. Okay, everybody. We're back in session. Donna, do you want to carry on?
Yeah, Cody, if you'll put the slide deck back up. We're just about done with the cost analysis. Just one more item here, and then a couple of quick words, and then we're going to turn it over for discussion for the rest of the time. So the last item on this cost category for state bar costs is staffing and personnel needs. As I mentioned, this cost is based on the percentage of staff compensation and indirect costs that relate to the bar exam. This is the number that was presented to you during the November 2025 discussion of the fee analysis. And it is there are increases or decreases for each option based on the need to bring on additional exam development, additional exam development lead, if we go with use of Kaplan, or the reduction in the need for exam administration staff if we go with adoption of next-gen UBE. And that is largely attributable to it being a computer-based exam. The amount of work that is involved with a paper-based exam is significant. For those of you who haven't visited a bar exam test site, I encourage you to do so and take a look at all of the boxes that we ship. Everything that gets shipped obviously has to be packed by staff beforehand. So we are copying forms, packing boxes, creating proctor folders, creating folders for testing accommodation applicants. shipping all of those. Then, of course, once you ship it, you then have to unpack it, and hand things out and take things back, and then at the end of the exam, you have to re-inventory everything and then repack it and then wait for the delivery trucks to come to get those delivered. So there'd be a lot, there would be significantly less materials that would need to be shipped to other sites. And so there would be a savings with the exam administration staff. There is potentially, I note here in the comment, there might also be a likely ability to reduce exam development staff. That's not something that I'd be able to confirm one way or the other between now and the final analysis, but it's just another caveat that the cost could further decrease. And then also we list here the cost for psychometric support. The NCBE would be doing the psychometric analysis of the scoring, of the grading, of the calibration, all of that, and so that would reduce the costs that are related to the bar exam for the contract we have with the psychometrician. The psychometrician does other non-bar exam related work. They do work related to the first year law students exam and the legal specialization exam. Those costs are not listed here, but that is part of our contract with the psychometrician. Next slide. Next slide, Cody. And that just brings us to the total. So as we said before, annual costs about $1.5 million different in the annual cost between option 1 and option 2, with all of the caveats that I had noted, which could further lower the cost of option 2. And then there is about $2.1 million of sort of one-time or short-term costs related to the Kaplan contract. So we're looking at $3.7 million difference between the two, but the annual difference, again, about 1.5 plus for the things that are not costed out. And then again, just being clear, for the examinee, there is a separate $149 fee that they would be paying directly to NCBE. NCBE does anticipate that cost will likely be lowered after July 2028, because that amount is what funds the backup laptops that are available at all of the sites, which are currently 10 backup laptops per 100 applicants and 1 tech proctor per 100 applicants. Their experience so far is that is much larger than is needed. They wanted to ensure that the jurisdictions had a comfort level that should there be issues with the platform, there would be laptops that are available to the applicants, and that there would be tech proctors available to the applicants. And they do not anticipate actually, based on the beta test and other tests, they do not anticipate needing nearly that number of backup laptops or tech proctors. And so with a reduction in those numbers would come a reduction in that $149 fee. That's it for the cost section of the risk-benefit analysis. What I wanted to do now was just ask you, with regard to this and anything and the rest of the risk-benefit analysis, what further information or research do you need for us to include in that risk-benefit analysis? Because recall, we will be presenting the final version of the risk-benefit analysis for adoption by CBE at the CBE's April 17 meeting. We will then be delivering to the board CBE's recommendation for that CBE recommends be submitted to the Supreme Court, and CBE's determination that the risk-benefit analysis is final. We'll be presenting that to the board at your May 15 meeting. Shortly thereafter, we need to expeditiously turn around a petition to the Supreme Court here is the cost benefit analysis with significant background, for them to then make to make a decision that we would then provide our public notice, use to provide our public notice. So we do want your input now about what else might be needed in order for you to consider this appropriately comprehensive and final and appropriate to submit to the Supreme Court.
Trustee Harrison, there you are.
Yes, I just wanted to make sure that a group of test takers is not being ignored in this risk-benefit analysis, and that would be those who have disabilities and need accommodations to take the test remotely. Now, I know that we have discussed at length that there's not sufficient bandwidth or technology for a broad-scale remote exam. But what about the small set of those test takers that have disabilities and need accommodations? I think we shouldn't ignore those people. So I would like them to be included in the report from a Kaplan perspective and from a NextGen perspective. Thanks.
Absolutely. I do just want to point out that they are included in the report. What I think arguably is not included is the discussion of those test takers who believe that what is needed for equal access to the exam is a remote administration. As I note in the analysis, NCBE has contracted with an organization called Level Access, I believe, which is a third party doing an audit of the accessibility of the platform. And they are providing recommendations to NCBE. NCBE's intention is to receive full certification from Level Access before the July 2026 exam, so this July's exam. I would also note that we took a look at the numbers of requests that we get from those seeking accommodations for things that are included in the platform itself that is being utilized for the NextGen UBE that are not currently in the platform that we utilize to give our exam, things like speech to text and text to speech, which is included in the exam, in that exam platform, that is requested significantly more than any requests for remote accommodation. Similarly, we get requests for stop the clock breaks, and we don't provide them. We provide alternatives. If somebody is entitled to a stop the clock break, instead we'll give them an extra time on the exam because we do not do stop the clock breaks. Stop the clock breaks are included in the platform. We get a lot of requests for that. So the things that we get requests for that are not included within our platforms that we have to figure out workarounds for are included in the NextGen UBE platform. And those are things that are requested considerably more frequently than a remote exam. And remember, right, we have to do the analysis of ensuring that the accommodation that is requested is necessary in order for the applicant to have equal access to the exam. And so it may be that the applicant is requesting a remote administration, but that there are other ways to address the functional limitations that the applicant has to address their disability to ensure that they have equal access to the exam that don't require remote administration.
Okay. I just want to share a short story about a law school friend of mine who had an immune system disorder, and the stress of having to go and stay in a hotel and take the exam in person. Although she had accommodations, it caused her immune system was so stressful that it attacked her own body and she almost died. And so the ability to take the exam remotely, if your doctor says that that is something that you require, I just want to make sure that's specifically addressed for Kaplan and for next gen UBE.
Other questions, comments, requests? Trustee Grande.
One thing, and I was just going back through the staff report, that I'm not sure if there's a way to quantify this, but I think one question that I have is, given we still have this Supreme Court order from 2024, how much are there any cost savings or additional costs incurred that if we continued using the Kaplan questions in the meantime, or if we use next gen? I mean, I know that they're separate conversations, and I'm curious that if we did use the Kaplan questions over the next 2 years, how useful would that be cost-wise, assuming that we're to continue under the direction of the October 2024 order?
So some of that I can answer. Some of that is everybody's favorite answer of it depends. To be crystal clear, the Supreme Court issued an order October 10, 2024, saying what the future California bar exam should be. That order is in place and until such time, unless and until it gets replaced. The conversation that we've been having would be, should we make a recommendation to the court to do something different to replace that October 2024 order? So we'd never be doing we wouldn't, both of those things wouldn't be in place, right? We are suggesting to the court, maybe you should reconsider that, and you should reconsider it with the two options that are currently on the table, right? Next gen UBE without a California component, in lieu of what you ordered in October 2024, or use of Kaplan until we get more information, and then you don't know what we'll recommend at that time. The Kaplan contract and the Kaplan exam was always intended to be a bridge. It wasn't intended to be the new exam. The October 2024 order lays out 12 subjects that must be tested, some of which are not currently tested and therefore not within the subjects that Kaplan is producing. The order talks about skills, which aren't written. None of those, the skills or the subject areas that the court ordered, have been incorporated into these questions. There was a thought that there would be more. So some of these areas, would they be testing laws of general applicability? Would they be testing California law? Right. That, those are things that are to be determined. Could it be that some of the essay questions and the performance test questions that we get now from Kaplan and over the next couple of years from Kaplan would be in subject areas that are within the 12 that were identified by the court and are a sufficient mix of California law and laws of general applicability, and we decide we want to continue to use essays and performance tests as the tool for testing, then yes, those could certainly be reused. Could we, to be right, just to sort of think even more about it, could we say, okay, we want to keep the essays, the performance test, and multiple choice questions, and Kaplan, we just want you to pivot, and we want you, instead of having multiple choice questions on the MBE subjects, which are what they have now, we want you to develop multiple choice questions on employment law and administrative law and procedure and family law, which are part of the new subjects. Yes, we could do that. We could renegotiate the contract for that. We could say, Kaplan, we're going to eliminate the essays going forward. But we want, so instead of giving us as many essays as you give us, don't give us any of those, but really bump up the number of performance tests or multiple choice questions and put them in these areas. So there are things that theoretically could be done, but the original thinking behind the new exam was that we would be looking at, innovative design. It could be, it wouldn't be multiple choice essays and performance tests, the same combination of what we have now, just different subjects, right? The idea was to incorporate skills and to do that through different things, maybe simulations or other ways to possibly add those assessments of individual skills. So there's a big it depends there, I guess.
And thank you. And then I guess just to get clarification, what we're deciding right now is, given that it's because you said something and now I'm like a little confused. So the recommendation we're giving to the Supreme Court, or we will, is for this, potentially for this 2 year. I thought it was for this bridge period of time, and then not necessarily recommending that they go in a different direction from the October 2024 order. Or are we, is what we're saying right now, or what we're considering, going to go back and say, yes, we saw the October 2024 order and we're recommending you do this like in perpetuity? Because I think, yeah, if you could just.
That's an incredibly important clarification. So there were 8 or so options that were presented to these bodies in January. And there were versions of them that were next gen with or without a California component as a bridge to the exam that the Supreme Court ordered. That was not the one that was selected. And what was selected was next gen as one of your 2 options. Next gen. Nothing is in perpetuity, right? It would behoove us to continue on the path to every 7 years doing a job analysis to determine what are the skills and knowledge areas that entry-level lawyers require. And if that analysis tells us that what is being tested on next gen no longer matches the skills and subject areas that are required for entry-level attorneys in California, then we would need to consider creating our California-specific exam. So nothing's in perpetuity, but for the next gen option, that option was, that's what we're going to do in 2028, and that's what we're going to keep doing until at some point in the future we decide something else. The use of Kaplan, on the other hand, was, as I described it, more of a deferral of a decision than a permanent decision. It was, let's use Kaplan, the Kaplan questions, so we can get more data on how NextGen is performing, and then we can make a decision at that point. Do we want to go NextGen? Do we want to go something else based on what we know after NextGen has been tested with examinees and gotten data after 5 examinations, beginning July 26 and ending July 2028. Does that make sense?
Yes, and thank you for that important clarification, because I think I was under the impression that the direction of we're still going to proceed with the order from the California Supreme Court, even if NextGen was adopted. So thank you for clarifying the way that we passed the resolution was different. Thank you.
Paul Kramer?
Yeah, the way I look at Kaplan, we talk about Kaplan as if it's something really different. And it really is a continuation of the current practice, just substituting Kaplan for the national conference as the provider of multiple choice questions. It had to be that way because when we started to use them in February, we did not give the required 2 years notice that there was some change in the content of the bar exam, because we saw Kaplan's questions to just be the equivalent of NCBE's questions simply from another source. So we can keep going on, use that that vehicle to wait and see what we want to do. I would be against starting to work on the California specific exam if we're not sure that's the way we want to go, because that would be a lot of costs that would, we would have to fund somehow, probably on the backs of bar exam applicants. And if we're still weighing using the next gen exam, which I'm personally in favor of, waiting is fine, but we have to also think about the differences between what we would be doing as a California specific exam and what the next gen exam does. And I think those differences are relatively minor. There a lack of emphasis on some areas where California differs somewhat from other states' laws, and some topic areas. But given the difficulty of preparing our own exam, the likelihood we'd be reinventing the wheel as far as what the national conference has done, and that they're so far ahead of us, I just don't see that as a particularly useful exercise. I think I coined the phrase California exceptionalism, and I really don't think that we functionally are that different from other states that we need to spend a lot of time trying to be special. It's an inconvenience for the law schools. The main thing they told us was don't keep changing the game every couple of years. Settle on something so that we can prepare our students for it. And let's be done with that for a while. So I'd be in favor of just going forward now. The national conference is going to have to work out any kinks in their exam and delivery process, and we have time to observe and make sure that they do that.
Okay. Thank you, Paul. Trustee Tony?
I'm going to go after Trustee Barahona.
Awesome. Okay, thank you. Donna, I had one question around the staff time on both options. These are not like, I think these are really important numbers, but there are some costs that are not always visible. And so that is my curiosity. Like if we, can you just walk me through ultimately, if we go Kaplan, that does sound like it's more staff, it's cumbersome for staff. There's a lot more time. If there's an issue, staff are sort of responding to those issues fairly consistently. And those issues have decreased over time because we make some pivots, we make some changes, we get new test centers, et cetera, et cetera, et cetera. But I guess you could argue that ultimately the price or the cost we're seeing for the Kaplan is actually contained, and there's actually a lot bigger cost in the long term versus the next gen, which feels like there's going to be a concerted effort on the staff side to be in sync, I guess, with next gen, but that will reduce over time. I guess I'm just trying to figure that out.
Yeah, great questions, and reminded me of something that I meant to say, so the staff costs that are laid out here, again, are sort of and this is often one of the hidden costs, as you say, right? When we often report on the cost of a bar exam, we report on the direct costs. We report on the cost of the test sites and the cost of the proctors and the cost of delivery of materials. And so we've heard members of the public say it only costs us $8 million to put on the exam, and yet we receive revenue, twice that, because those are the direct costs, but they're not the indirect costs of staff compensation. And that's what we've included here. And that was part of the fee analysis where we really dug deep to figure out what percentage of staff time is spent on the bar exam so we could understand what percentage of compensation needs to be attributed to that. In addition to those dollars, though, that are laid out here, are the operational efficiencies. And there are significant operational efficiencies for administration of, and admittedly, any computer-based exam that doesn't have the paper. There would be significant operational efficiencies. The amount of time that we would not have to be prepping for the exam. And to be clear, when we are in the upcoming, in the sort of month and a half coming up to the bar, it is not just the small group of exam administration staff that are packing boxes, that are preparing the proctor folders, that are stuffing the TA envelopes. It is an all hands on deck experience. And so to the extent that we don't have to do that, then the moral character staff can be answering moral character questions. The special admissions staff could be answering special admissions questions instead of doing exam preparation. So there's a significant operational efficiency with having a paper-based exam. And so that is an important thing to point out. We also, as I have mentioned in the chart, I think we would ultimately be able to reduce exam administration staff. We would do that through attrition and moving staff to other admissions positions that are available. We may also be able to reduce exam development staff as a result, because we in the past couple of years have increased exam development staff to address all of the incoming content that we're getting from Kaplan and the need for content validation. So we would likely be able to decrease not just exam administration, but also exam development staff, redeploy them to other things, and maybe make ourselves better and more efficient in other areas of our operations.
Okay, thank you. And then just two other things. I'll try to be quick. I think the thing that needs to be included here too is a bit of a list of all the kind of the summary of the public comment in terms of those that support a particular option and those that support a different option. I think kind of seeing the whole of this, not only with what the deans have communicated as their preference, but sort of the whole picture. I don't know if there's a way to concisely gather that data. I think that's so I want to put that out there because I think that's important. And then the third thing is that we're talking about a user experience at the end of the day. And so my curiosity is, have we ever done like a user experience, like, or hired a UX consultant to sort of help think through a product and the experience a user is having with that product?
So we, not to my knowledge, have we brought on a user experience person. What I would say is that NCBE did that. They brought on user experience experts in working to develop the platform that is being used. So that is something that they invested in. I note in the staff report that, and again, this isn't an impact for Kaplan, but if we were to ultimately develop our own exam, there would be significant exam development costs, or even if we frankly had to, if we decided we wanted to load the essays and the essays and performance tests into the system. NCBE reports that they basically doubled their staff to work with ITS to design their platform, to bring on the user experience consultants, all of that work to take on the development of the exam. If we were going to do our own exam, none of those costs including increased staffing costs, if we were going to do something that is developing our own exam after that use of Kaplan period expires, none of that is included in here.
Got it. And then could NCBE give us a high-level summary of that, of how they got to that design experience? Can they give us some of that data?
I can certainly reach out to them. They've been very responsive to me, and I can see what they can share about that.
Wonderful, thank you.
And let the record show Member Burns of CBE is joined. Welcome, Crosby.
Thank you.
Trustee Tony.
Yes, thank you very much. You know, I spent a lot of time thinking about this. And so what I want to share is a presentation that I put together. And Sharon, if you could put it up, of how my thinking has evolved. So the first thing I want to do is appreciate everyone who has presented comments leading up to this meeting, including Gil Pellis from the LA County Bar Association and the 62 bar associations that represent counties from across the state, diverse, prominent minority bar associations, LGBTQ plus bar associations, plaintiff, defense counsels in many areas who submitted comment in support of a California bar exam using Kaplan in a remote setting as a bridge. Viviana Garcia Barnwell for organizing a joint letter signed by DEAR, Disability Education Accessibility Resources, All Things Disability, Cal Tash, College of Adaptive Arts, and Spire Autism to advocate for properly administered remote testing to increase accessibility and eliminate barriers for disabled exam takers. Jules Sarkar for submitting comments supporting using Kaplan to offer remote exams and flexible testing options. Benjamin Cohn for pointing out concerns that Next Gen exam fails to adequately offer acceptable accommodations to test takers who require accommodations in order to be tested on a level playing field with other applicants. And Ray Hayden for providing an assessment of other professions who utilize remote testing options to grant licensees to their applicants. Now, if we can go to the next page. So what I did is there were so many numbers in the surveys, and I sure appreciate it, but I decided to look at 3 questions that were important to me to try to understand where people were at. Remote administration, testing frequency, and assessment knowledge of entry-level California practice. And with remote testing, there were 2 groups, the 1,600 prospective exam takers and unaccredited law school deans who felt very strongly that there should be remote administration, along with the CALs, the state-accredited law school deans. But when you looked at the 12,000 licensees, they felt very differently, as did the ABA law school deans. So I'm only saying that, to me, there is not a consensus that remote administration is a strong, there's not a consensus on that. And in some ways, I weigh it against. Testing frequency, similar. And in this, only the 2 groups, the prospective and the unaccredited law school deans, indicated that testing frequency was very important to them. And it drops down after that. What's interesting is there appears to be a consensus that having an assessment and knowledge about California practice is actually extremely high or very important to all of the groups who disagreed on the remote and testing frequency, and strong. as opposed when you compare it to the extremely and very unimportant, that's meaningful to me. So let's go to the next page, the final page. I just wanted to highlight the comments of Chief Justice Guerrero, as reported in the press at her annual press conference, which, by the way, happened after we last met. That is the joint Board of Trustees and Committee of Bar Examiners. And we got the Daily Journal where it says, finally, Guerrero addressed the fiasco of the February bar exam and reports that the bar is still exploring adding a California-specific portion to the test. We have the recorder that reports that Guerrero said that she wants to see what state bar leaders recommend. She feels more comfortable with the next gen exam. It just seems like next gen, they're doing a good job. I'm not saying that the other alternative is off the table, but you ask what I feel about next gen and what I heard from others, what I've seen, they're doing a good job. We go to Bloomberg. Everyone has a different role to play, trying to get on the right track for the purposes of students and the public. Guerrero did highlight that California-specific exams could offer remote opportunities for test takers, which weren't available under Next Gen. However, in the debate that has left bar leaders deeply divided, Guerrero cast her vote. I feel more comfortable just personally with the Next Gen format after having gone through the February fiasco, Guerrero says. Now, look, this is what's reported in the media, okay? And what I get from this is two things. One is that the Supreme Court, or at least the Chief Justice, is signaling that she would like us to seriously consider the next gen exam, and that she, along with, seems like the other survey participants, think we ought to seriously consider a California component. So I would say that what I would like to see from Donna is at least some pathway to a California-specific component that we could include in our May recommendation. So that's what I've got for you.
Thank you. Thank you, Trustee.
Donna. Yeah, so if I may just address it a little bit. This meeting, today's meeting, is not agendized for action. Regardless, we are at a point now where we are a couple of months, literally, from making our final, the final recommendation to the Supreme Court. As a result, we do not have time to make a recommendation that a California component be included in a July 2028 administration. Because in order to do that, we would have to have conversations about how is that component going to be delivered? Is it part of the day and a half fully proctored exam? Is it a separate online module that we do similar to New York, Maryland, Massachusetts, some other states, where we are, instead of sort of testing for minimum competence, but rather we are testing for ensuring familiarity with key concepts of California law that we need to test. We'd need to develop content maps for, as part of the notice, there would need to be content maps about what would be on the exam. So what I do see as possible, though, is, and frankly helpful, is that when the final recommendation is made, one of the things that the board could weigh in on is whether we should include in the petition that goes to the Supreme Court with the recommendation for what would be implemented in July 2028, whether we should include in the petition a discussion about if the Supreme Court is interested in us pursuing a California component along with NextGen, then what would be incredibly helpful, it would be if the court would identify what are the subject areas they would like for us to test. That way, we could have a real head start on taking, the next year to develop the content maps, to develop the direction. Is it being tested during the day and a half? Is it being tested after? We could do that over the course of the next year to make sure we have enough time to do it accurately so that we could present a new cost-benefit analysis to the court in roughly same time, June of 2027, right? So a year later, that says, and we'd like now the California component, which would get added on 2 years hence, to look like this. And then they would adopt that or not, and then we would have time for our 2-year notice on that. What the end result of that would be under that scenario is July 2028, NextGen without a California component. July 2029, we add the California component. So that might be, Trustee Tony, a way to, something specific that could be incorporated in your May recommendation that would move us forward and signal to the court if the board is interested, if they are in moving forward with the California component. That would be a way to signal that to the court and get them to help us move our analysis along.
Donna, I really appreciate your thoughtfulness in your response here. And what I would like, I'll tell you what I would like to see in May. I would like to see more than one proposal. I have always not been happy with a single proposal at the, for action on major issues. I would like that to be one of the proposals that's presented, not the only one, but one of them. Thank you.
Thank you. Trustee Harrison?
Yeah, yes, thank you. I just wanted to share that, for a while now, I've been against the next gen option, but given what was presented today and after all the consideration that has been put into this, I think that it's probably the most prudent way to go for now. I don't like the fact that there are subject matter criteria in the Supreme Court's October 10th, 2024 order that says that the state bar should be looking toward testing these specific subject areas, and NextGen does not test those subject areas. But we haven't disavowed moving toward that in the future. And so I'm leaning toward NextGen. I just wanted to share that.
Thank you. Trustee Huser? I think you're muted.
I'm sorry, I was on mute. I just wanted to add one comment to address Trustee Tony's comment about the California specific. I just Googled that 66% of California test takers for the bar have attended law school in another state. Or I'm sorry, 66% inside California and the remainder in another state. So one of the issues with having California specific questions on the bar exam is how those non-California law school students or students, they may be foreign students, LLMs, things like that, would have the opportunity, the same opportunity as other test takers who had attended law school in California. That would be just something that I think was interesting and noted. And then I think this was stated earlier today. I think we heard from all of the law schools that one of the important things is don't keep changing the game, because law school is a 3-year process and they've got to give these kids some indication of what we're going to be testing. And so I would just encourage us to try to keep that in mind. Thank you.
Thank you. Trustee Grande.
I wanted to share that I think that given the conversation, and then Trustee Tony, thank you for, or Vice Chair Tony, thank you for putting together that presentation. I I would be interested in look in whatever we come up with that we do take on not having this be necessarily our recommendation in lieu of the October 24 order from the Supreme Court, but rather this is what if this is the direction that the CBE and the board moves forward with, that this is a bridge, and then that shortly thereafter we start to create, well, what do we need to be able to see from the next gen exam to know that we're fulfilling on ensuring that anyone who passes that exam is at the level that we would want them to be at for California. And I do think those questions that you brought up, Trustee Tony, in terms of bringing a California component to it is really important. I know that family law and probate and estate planning are very California specific, and there is a lack of attorneys going into those fields, and I do know that there is a desire that if people are licensed to practice law here in California, they can do so competently in those areas that we have a huge population needing those services here.
If I can just clarify, because I heard two very different things in what Trustee Grande was just saying. So I can absolutely sort of see your point of it's incredibly important that we frankly sort of forecast that what we are going to be doing, that if what we do is adopt next gen UBE, that that we have a timeline in which to come up with performance criteria so that we can assess if it is doing what we wanted it to do. Makes perfect sense, and we should give ourselves we should ensure that we are making ourselves come up with what is it that we are going to be assessing to make sure people are performing, to make sure we are ultimately comfortable with this decision that we have gone to. But what I also heard, which is in my mind very different, was you saying this is a bridge to what was already ordered in 2024. I think I see it as just assessing whether the determination was correct and if changes need to be made in the future, as opposed to a bridge. I also sort of, one, maybe selfishly, two, because one of the reasons we asked for direction in January was so we could develop the risk benefit analysis. You gave us two options to develop, which we have, the next gen UBE and Kaplan as until we make sort of a further decision going forward. So that's Kaplan as a bridge. But to a bridge to a future decision, as opposed to a bridge to a specific exam. Because you can't take an action at this meeting, you can't sort of add what we're looking at as Kaplan or Next Gen UBE as a bridge to the new California exam. That was one of the specific options that you didn't select in January. And so I just want to make sure that that I can implement your request in the way you want, and that it's more consistent with what I was originally saying, that we're coming up with metrics to make sure that and a timeline for us to determine that NextGen is performing the way we would want, and we don't want to reconsider that decision.
So if I can just clarify, and that, I can own that I miss that the next gen option was saying we are saying we're asking the Supreme Court to completely reconsider their order from October 2024. I think one thing that I'm just uncomfortable with is that the Blue Ribbon Commission did all this work for several years to study and come up with recommendations, thoughtful recommendations, and presented that to the Supreme Court. And after whatever conversations they had, they, issued that order in 2024. And that because of because of the issues of the February 2025 bar exam, that we are I personally just am uncomfortable with not ensuring that whatever choice is next is doesn't fulfill on the objectives of that original commission and the order of the Supreme Court. So I that's where for me it would be that first piece of it is super critical for me because whatever happened with the February 2025 bar exam, it is obviously impacting our decisions today. And I think there's, with everything going on, there's a lot of things that we're learning about what worked and didn't work in that process. But I wouldn't want to say this is what it's going to be moving forward without actually intentionally making sure that this is doing what we needed to do for the state of California.
Thank you. I thank you. Member Kramer? You're muted, Paul.
Since the Blue Ribbon Commission made its recommendation, the next gen exam is, has been much more clearly defined. A lot of work has been gone on with it. I think it's quite possible if you re-polled the members of the Blue Ribbon Commission with the knowledge that they now have about both our abilities to give a remote exam with the technology limitations we have, and the more clear development of the next gen exam that they might recommend for it. So, and I don't think the court is obviously open to reconsidering their decision for those same reasons. So I don't think we need to feel obligated, to have a meet some sort of exceptional burden of proof to be willing to recommend to the court that they change. I see maybe we should quit calling it a bridge and call it a holding pattern, because that's what it really is keeping the existing practices in place, the Kaplan that is, until we can kick the tires on next gen some more. And if we decide that it's not going to work for us, then we'll have to take another 5 years or more to develop our own California specific exam. And I'm against that because, one of the clear messages of the Blue Ribbon Commission that I think is still valid today is that the old test is no longer the best way to assess new lawyers. So we should be checking more for skills, de-emphasizing the memorization of rote law. And the next gen exam does that, and it will be available for us as soon as we are available under the noticing constraints to take advantage of it.
Thank you. Final comments? We're approaching the 2:00 hour, and our examiner still has considerable business. So I'd like, let me ask Donna and Cody, you feel you've got sufficient guidance as to our next steps?
Well, before that, I'm going to go ahead and comment because I think that this is an important question as to what lies beyond this. And I just think that Trustee Grande brings up a very important point, that until such time that the Supreme Court rescinds their October 24 ruling or decision, however you want to call it, I feel bound to it. And that us choosing, should we choose to go with the next gen, does not automatically mean that we have foregone that. And I think after the May meeting, we should have a deeper discussion about the California only exam and ask the staff to prepare a plan for it. I want to see a plan. We October 24th, this is a year and a half, and I don't know how much work has been done on it thus far. I'd like to know that, what the progress is. And so I think we don't have to decide in May that we absolutely are going to do that, but I also don't think it's appropriate to decide in May not to. I just want to focus on the July 28 and the ones after that. Thank you.
Thank you. Any further comments?
Yeah, I'm sorry, Alan, just one. I would like to see, I'm sympathetic to the need to test for the California specific differences from black letter law. I don't know that that has to be in the form of an exam, though. It could be in the form of an orientation for new lawyers. If we accept that the next gen or whatever bar exam is determining that they have the specific skills, then it's simply a matter of educating them. So I don't know that it has to be in the form of a test. It could be in the form of continuing education, mandatory for new lawyers.
Thank you. Further comments? Seeing none, thank you very much, everybody, for your views. I think we've given staff some guidance, and we will take this up again in May or in April at the Committee of Bar Examiners. Jose, I think it's your call now to end the meeting.
Yes, Alan, thank you very much, and thanks for a very good conversation from everyone. With this, we'll adjourn the joint meeting. Alan, I believe you might want to take a break and then adjourn the Committee of Bar Examiners meeting.
We'll start up, the Committee of Bar Examiners will start up again at 5 minutes after 2. Thank you.
Thank you.